All right, John, thanks. As classes resume for in-person learning, some school districts are requiring masks, as you know, while others are leaving the decision up to students and parents. But what happens if the parents are divorced and they disagree on whether a mask should be worn during school hours? Fox 2's Margie Ellisor spoke with a family law attorney to get some answers. Margie?
Yeah, good morning, Randy. Well, the pandemic has certainly brought new challenges before our family courts. When parents have shared legal custody and they disagree on what's in the best interest of the child, it can be complicated. Last school year, wearing masks was mandatory for most area districts. Well, now some schools, as you mentioned, Randy, they're leaving that decision up to parents to decide. So what happens when one parent feels strongly the kid should wear a mask and the other feels just the opposite?
I think the reality is no one's going to go run to court as to whether or not they should get a temporary restraining order to put a mask on their child to go to school every day. And ultimately, what you're going to see is it's going to be up to the parent for purposes of determining when the child goes to school that day, whether or not they're wearing a mask. So it just kind of falls into that same situation with the daily decisions that need to be made, because ultimately, if two people can't agree as to what's in the best interest of their child, by the time they would get to court and try to have that decision made by the court, the harm has already been caused if somebody really is going to get sick during that time period by not wearing the mask.
The issue with mask wearing may be just scratching the surface of an even bigger problem. What if parents disagree on getting their child vaccinated against COVID?
Look at it this way. When you're going to register your child for public school, the reality is they're going to make a requirement to see the medical records of the child and determine whether or not the child has been vaccinated for various things. And if the child has not been vaccinated, they're going to request that you apply for and receive a religious exemption for them to be able to allow the child to enter into the school. So I think it's going to be the same thing. The question is whether or not, based upon the harm that is being shown by the spread of the Delta variant and the pandemic, is that going to override what would have been for other things that have been accepted for purposes of the religious exemption? We don't know that yet. Obviously, it's going to get before a court at some point in time, but today we don't know the answer to it. But I would look at it very similar. But because of the harm that can be caused and the spread, is a court going to look at it differently because of the fact that we're seeing the effects of what can happen amongst unvaccinated individuals who subsequently contract the Delta variant?
A recent study by Parents Together highlights that fewer than 60% of parents plan to have their child vaccinated against COVID. So that leaves 40% undecided or unwilling to vaccinate. Mark says with the vaccine soon available for kids 5 to 11 years of age, if you think you and your ex will disagree on your child getting a COVID shot, addressing this issue now before the child is eligible is wise and may save you a lot of time and energy and even possibly money. Ideally, parents will come to an agreement before the argument goes to court. For more legal advice on this issue, head to stlmoms.com.